Good afternoon. Welcome to our special Best Practices webinar series today. My name is Steve Kessler with Vertical Alliance Group. Our webinar today is sponsored by Classic Truck Insurance and Services, and it's a great program. We've got some really important information that everybody needs to know about, and it's regarding a new FMCSA law that affects the freight brokering business and in fact prohibits motor carriers from brokering freight beginning October the 1st. But before I introduce our guests today, let me just say that we've got a large number of people on the webinar today, and everyone is muted, which means we can't hear you. You've got a place on the little panel on your screen where you can type in a question. So anytime during the program, if you've got a question, feel free to type it in. That pops up on a screen here on my end, and I will, after the presentations are completed, pose those questions to our guests, and hopefully we'll get those answered for you. I also wanted to let you know that the webinar is being recorded, and we will be sending an email after this webinar today to those that attended, but also those that registered that couldn't attend. That'll have a link where they can listen to the recorded webinar or share it with some other people that might not have been able to attend today. And we'll also be including in that webinar, or in that email, a copy of the slides that are going to be used in the presentation today. So having said that, let me introduce today's guests. Our primary presenter today is David Dwinell. David is spent virtually his entire life in the transportation business. He's been a driver. He's owned a trucking firm and brokering houses. David's a graduate of Wisconsin State University in Whitewater, Wisconsin. He is the author of the New Transportation Brokerage Operations Manual and is also a published author of numerous articles about transportation brokering. David is a leading forensic expert in the subject of transportation brokering, as he has brokered daily since 1981. Our other guest today is Temple Scalf. Temple has spent better than 20 years in the truck transportation industry, some 14 years with the Peterbilt truck dealership system. He then moved into the ownership of Classic Truck Insurance and Services, and is a licensed property and casualty agent secured in 46 states. Temple's a 2005 Master Broker graduate of LoadTraining.com, which is David's company. And Mr. Scalf represents Great American Insurance Company Bond Division, which offers the $75,000 VMC 84 bond needed by freight brokers today. So with that said, I'm going to turn the presentation over to David Dwinell. David?
Yes, thank you very much, Steve. It's interesting, of all my experiences in the many years I've been in the business, to see a law like MAP 21 passed that literally turns the industry on its head. The law is completely incongruent. Apparently, the law was designed to get rid of bad brokers, but it requires everybody, truckers, forwarders, NVOCCs, and others, to become licensed brokers to work with another motor carrier. And so, in my opinion, the trucking companies gave up more than they got for the law, because the law affects brokers in a very, very marginal way. To a broker like myself, I merely have to pay more to get my bond. So the impact on brokers is relatively negative. However, the impact on truckers is immense. It's huge. It requires, for example, that a trucker can never work with a trucker without a broker's license. And when that happens, that licensed of that motor carrier brokerage is the only one who can work with the other motor carrier. The original motor carrier who got the broker's license cannot work in any way with the other motor carrier. And this is the biggest impact. Because an enormous amount. In my estimation, $300 billion a year is brokered from one motor carrier to another. And that means that one motor carrier with authority works with another motor carrier with authority. The lessors or owner-operators are unaffected by MAP 21, as they are not carriers by law, they are lessors. So what I understand the purpose of the law was it was a name that was assigned in 2010, 2011 in the congressional attempt to pass a similar verbiage law, and it was called the Motor Carrier Protection Act. So essentially, MAP 21 is designed to protect motor carriers from the predations of brokers and to eliminate double broker. Double brokering means when more than one broker takes or each take a commission before the carrier gets paid. That is double brokering. And the law's effect is to create transparency in the relationship between carriers and brokers. And of course, that remains to be seen. This entire law, the effect of the law, the amount of government work is going to take to enforce the law is literally unfathomable. So I think all my comments today should be prefaced by the fact that if the government enforces the MAP 21, and of course the Secretary, Farrow, announced on August 29th in a memo to the public that they don't have the resources to enforce the law, but that they are throwing everybody in the marketplace out to right of private action. And what that means is that people who are breaking the MAP 21 are subject to private lawsuit that will literally be backed by the FMCSA. So essentially those people who are trucking companies or working with other trucking companies, if they fail to pay the second trucking company, that second trucking company has a right of action against the first motor carrier because they're brokering without a license. So this is the main impact of MAP 21, the fact that these two companies, one is the trucking company who may not have a license. He has to go out and get a new license or a license and post a broker's bond. And that these two companies have to be completely separated, one from the other. In fact, under the FMCSA recently published FAQ section on their website, fmcsa.dot.gov, they actually indicated that the trucking company and brokerage in the same ownership cannot even share payroll. They have to be totally, completely separate, different addresses. Now, we all know what goes on behind closed doors is essentially trucking, dispatch, and brokering occur on the same table in virtually everybody's office. But the effect of transparency is that the carrier has to, if he accepts a load from a shipper, if he accepts a load from a shipper, he has to inform the shipper that his brokerage will be the one finding the other motor carrier and that the brokerage will bill that shipper. Motor carriers won't have any ability to bill for loads they accept because under MAP 21, when they separate these two companies, the trucking company cannot be involved in the revenue because if they take the revenue from the shipper, deduct their commission, give it to their brokerage, who deducts another commission, that in effect is double brokering. So this is going to be an interesting turn of events for everybody in the business. And it's a huge business, largest industry in the world. But it's a very small fraternity, especially for those who comply with the law versus those who don't comply with the law. So that does it for brokering, but the impact of this law is that no broker can take a load from a motor carrier. If a broker takes a load from a motor carrier, the motor carrier has taken his commission, given the load to the broker less that commission. The broker turns around and works with another motor carrier and takes another commission. That's double brokering. So essentially, you might say that truck brokering, as you understand it, is outlawed. The only brokering allowed is by licensed property brokering. Slide. So, said another way, no trucker may hire for loading another trucker to balance his dispatch, except by long-term lease. No trucker can take a load off a load board for brokering purposes. They can only haul that load in their own equipment. No trucker may take possession of cargo for brokering purposes. And truckers who own trucks cannot broker, cannot take possession of the cargo unless by permanent lease with a hauling trucker. No truckers may appear on a bill of lading for a cargo they are not in possession of. Slide. So we've seen the impact on truckers. Let's take a look at the impact on brokers, effective October 1st. As I said before, broker surety bond increases $10,000 to $75,000, but the actual cost of the broker is relatively marginal. Say $1,000 a year for the $10,000 bond is now going to be perhaps as low as $1,800 for a $75,000 bond. So the impact on brokers, fairly small, fairly insignificant. Now, this significant part on an effect of brokers is that they must reapply for their own bond and license every 4 years, but when you add in the year of application, it's effectively 5 years. Which means that if you've invested $1 million in your brokerage and you have a ding, so to speak, or you have a failure to pay a motor carrier, the odds are very good that you will be barred from the business for 5 more years. The all-new broker's license applicants, another little effect, all applicants must receive training or prove 3 years prior brokering experience in order to qualify for a license and a bond. Although at this early date of the imposition of this law, insurance companies and surety bond companies don't necessarily have in place a place where they can actually check for 3 years brokering experience or whether or not they've received training. The law mentions that training must be a complete understanding of the laws about brokering, which is fairly insignificant. In the regulations, there's one regulation required of brokers, records to be kept. Fairly small amount of training for that. Here's a kicker. If you're a broker, or you're a motor carrier, or you're a shipper, the penalties for unlawful brokering could be as high as $10,000 a load and or subject to a right of private action. So in other words, if a shipper is a party to a double brokering, they may be named. And most significantly, no broker may ever work with another broker without an actual co-brokering agreement. That can only allow 2 brokers to split 1 commission. As I said in the definition of double brokering, any transportation act where 2 brokers each take a commission each from the revenue, by definition of MAP 21, is double brokering and illegal. And most importantly, in any co-brokering agreement, just like real estate, the broker with the load has to pay the actual hauling carrier. So that means the originating broker with the load should also check and verify authority and insurance of the hauling carrier to prevent double brokering. Lastly, no broker can take a load from a trucking company. This is big. Again, double brokering. So we've looked at both sides of the mirror, haven't we? And this has a huge effect on the existing marketplace because half the people on load boards are trucking companies brokering freight. I was at a recent summit with a load board and asked a question and couldn't get an answer. Are they going to still allow trucking companies to post loads for brokering purposes on load boards? Slide. Here's the impact on shippers. And keep in mind that a broker is a shipper. He is not a carrier. Hasn't been since 1993 in the Negotiated Rates Act, where brokers were found to be shippers and not a carrier. And if you actually read the regulation defining a broker in federal regulation, you'll see that motor carriers are barred from being considered brokers. So shippers and brokers are one and the same. Now, a shipper who allows double brokering subject to private right of action, in other words, if a shipper pays the broker and the broker fails to pay the trucking company, the actual hauling motor carrier has rights against the shipper that may extend beyond the existing rights they have in the bills of lading. Shippers may only install actual hauling carrier's name and motor carrier on the bill of lading carrier section. So in other words, the widespread practice that you probably are all familiar with is that shippers put on, for example, the largest brokering company's name on the bill of lading, and then another carrier comes in to pick it up, and his name does not appear on the bill of lading. Shippers may be subject to right of private action on that basis. Logistics companies, warehousemen, forwarders, some NVOCC and others listed, must obtain a broker's license, post a bond to arrange transportation. So all shippers and brokers are subject to MAP 21, even for exempt commodities. Slide. I guess the impact on surety bond companies is a little out of my purview. I'd like to turn the discussion over to Temple Scalf, who is an insurer.
Well, thank you, David. One primary part of my message is bond issuers cannot assure legal actions by freight brokers, forwarders, or motor carriers that are not in compliance with that new FMCSA regulations called MAP 21. So I recommend that all need a good consultant to help you to adjust to the new regulations. And our role is to look into this fog of misunderstanding as it's rolled out to us, and to help you identify the challenges quickly and comply with the new MAP 21 regulations. FMCSA guidance is slow, legalese to understand, and needs interpretation. So implementation of this law is viewed by most as a huge disruptor in the marketplace and will immediately cause instability for a while until everyone begins to get on the same page. So what's at stake for the broker, motor carrier, the forwarder? Well, their professionalism is at stake. Your market share is at stake. Your competitive advantage is at stake. And, of course, violations of the new laws with their subsequent fines are at stake, and that's certainly important. So we all need a good consultant. So let's talk for a minute on the impact of insurers and bond issuers who issue the bonds to brokerages, freight brokers and such. This is a general overview of bonding companies' requirements. Who will issue the $75,000 broker bond or trust fund, who many of you have already purchased and ready to roll out on October 1st. Security bond issuers who issue this new bond are required to abide by the language FMCSA legal department requires of them. And that's not different as it was comparative to before MAP 21, except there is some different language in the bond language, and that could change over time. So insurers have heightened their scrutiny that they give in the underwriting of this larger amount, which is 7 times more than the $10,000. That's a little bit more than that at $75,000. So purchasers of the new bond are experiencing in most cases, now this is in talking about bonding companies in general who are offering this new bond, that the applicants are experiencing increased approval requirements, such as increased collateral requirements, corporate and personal financial statements, net worth requirements, just to mention a few. And even upon application, some are getting turned down. In future, bond purchasers will be required by FMCSA to show they have a minimum of 3 years experience as a broker or forwarder, as David had mentioned before. And bond issuers will need to provide that part to be filled out on the application of your vocational experience in the business as part of their requirements to comply with FMCSA to issue that bond, in order to issue the bond. The majority of the bonding companies issuing the new bond want to assure there is sufficient business equity or personal net worth to support the larger bond. And the reason why these requirements have been extended is because the majority of claims on the bond come from those who have insufficient working capital. It's a little more difficult for a startup to qualify for the new bond, but the expense of the bond would not be too much different than a company with tenure. There are companies now that are existing under one motor carrier number, both the freight brokerage and the motor carrier operation, and they will be required, as David mentioned, to be separate fiduciaries. And under MAP 21, these entities are required to be separate, and bond issuers will look at the entities, both entities in some cases, in its entirety to issue a bond. So what are we saying is that it's going to be a little more difficult to actually get a bond. So what I'd like to say is we have performed a market study, and we have concluded that Great American Insurance Company Bond Division has the most brief application, not asking for some of the information that I've mentioned, and you can get a quote back in the same day. And it is, at this point in time, unless this has changed in the last 2 weeks, the best price nationally. And it is based on the ownership's personal credit, not the FEIN of the business. And so that will give all a break who care to look into calling the representative of Great American Insurance Bond Company to get the best arrangement on their bond today. So I will be willing to help you in any way that we possibly can. So I guess I would turn it back over to David or Steve.
Okay, this is David. I'm looking at the about compliance. I think we've mentioned that the government's not going to be very effectual in immediately implementing this law, so I don't think anybody needs to put on a hard hat or go to a shelter. But I do think that people should prepare, and I think the biggest thing they have to prepare for is that if you look at the contracts for brokering that are currently in common practice, you'll see that many of the brokers feel that the motor carriers work for them. By any interpretation of MAP 21, the brokers work for and in and for the motor carrier's interest and perform a function of essentially collecting from the shipper, paying the carrier less their agreed commission. Any other form of principal-agent relationship in a contract probably means that the broker is acting as a motor carrier and, of course, is liable for any loss that occurs. So, for example, in my textbook, I have a 1-paragraph long contract that complies with MAP 21, which essentially says the same thing. Mr. Carrier, we're going to collect from the shipper. This contract is between you and the shipper. I'm just your travel agent, or something to that effect. I don't have time to read the whole thing to you, but it's a paragraph long. Most brokering contracts are 20 pages. In fact, include clauses like indemnify the broker, include clauses that hold harmless the broker. Those are all indicators of a principal motor carrier agent carrier relationship. And brokers should avoid that at every change if they want to broker without liability. Because certainly the people who designed this law, basically the TIA, the ATA, and the WIDA, somehow wanted to make brokers more responsible, but brokers can effectively be a travel agent and say, sorry, the plane crashed. So in terms of compliance, this right of right of private action is huge. In other words, as an expert in this business, I've received inquiries from 2 states about how they're going to enforce MAP 21 at the scale houses. In other words, the states were looking for another way to put another hand in the trucker's pocket for fining purposes. So this essentially is a huge tax on trucking. And of course, if brokers are conducting their business as a travel agent and not as a motor carrier, they probably will escape the vagaries of all these collections. So I think the big thing here is that brokers can't quote freight rates of their own. They have to ask a motor carrier for a freight rate because a broker by this law is not a mode of transportation, nor may they assess a fuel surcharge to a shipper unless the fuel surcharge is pre-assessed by the motor carrier, and must pay the carrier for every load regardless of claims. In other words, who would assume the responsibility to conduct an act of transportation if there was a legal opportunity? They would not be paid in doing so. So the scheme of the law comes down on the side of those who take the risk of transportation and generally against those who pay for the service, such as shippers and brokers. So I don't know how anybody can comply, except that the big issue, I think, is contracts. And again, the broker is a shipper. So on that note, I think I've concluded my remarks. I think we're going to have a Q&A session. Anybody would like to write in questions, I'll be happy to stay and answer them.
Yeah, thanks, David. Thanks, Temple. We've got some questions, as I suspected we would. So I'm just going to take these as they were given to me in order. David and Temple, the first question is, what does this law do to the car dealerships? Do they need a broker license to transport?
I would suggest, and of course I have to put in this preface that I'm not licensed to practice law, but in my opinion, I would say that if the motor carrier is not owned by the auto dealership, they probably will have to do that in the event to avoid questions at scale houses when the names on the bills of lading and the name on the door of the truck are not the same. So I'm not sure how to answer that, but I would say given the sweep of MAP 21, they want everybody to become a licensed property broker. And so given the bent of the law, I would suggest that's probably going to go that way.
Okay. Thanks, David. The next question is, does MAP 21 have any effect on NVOCC and freight forwarder bonds?
I'm not certain how to answer that, and I don't know if the federal government has published anything about that, but it would certainly be an interesting question. But if the NVOCC and the forwarders are separate companies and they have to start their own brokerage, which is completely separate and distinct from their forwarder or their NVOCC company, they would have to post a bond for that company. So in my opinion, because basically the law is very, very clear. It says that nobody can broker freight except licensed property brokers. So whether it's an automobile or a container or a railroad TOFCO, I would think the way the regulators are going to come down on the side of the MAP 21 saying if you're not a licensed broker, it's illegal.
Okay, thanks, David. The next question is do 3PLs fall into this category?
Absolutely. For example, in MAP 21, there is a clause in there regarding coercion. Now, up from 1995 to date, it is a felony to coerce a driver into loading and unloading his own truck without compensation. So essentially now motor carriers were not subject to this, only shippers and receivers. Under MAP 21, that clause has been extended to, say, trucking companies, property brokers, intermediaries, which are 3PLs, and NVOCCs, and anybody who is required to register as a broker under this law. So now it's a felony even for a motor carrier to force a driver to unload a truck without compensation. So, and that's big. I mean, it says everybody in subject to coercion is subject to the National Labor Relations Act of 1932, which has huge penalties, 10 years or $10,000 or both.
All right. Thank you, David. Next question is, Clear Springs is a trout producing company that often looks to have loads picked up from our location. We use multiple contacts for this service. How will MAP 21 affect us?
Well, the shipper, Clear Springs, is tendering freight to motor carriers at an arm's length basis. They don't need to register as a broker, but the impact immediately on them is that if a truck shows up and it says Smith on the door and the broker Jones has his name installed on the bill of lading, Clear Springs could be liable in the event that the subsequent or the subcarrier is not paid. And of course the Silver Spring or the Springs, the shipper here, the trout fishing shipper, has obligations under bills of lading he creates. So he should make sure that the bills of lading he creates are for the trucking company who actually shows up at the door. And the way the courts are going here recently, shippers should actually take a picture of the man's CDL and treat the carrier something like they would treat in a hazmat hauling, to be a little bit more responsible in making sure they load, when they load a trucker, that trucking company is responsible.
Okay, good. Next question is, can a carrier give freight to another carrier? And I think this has to do with interlining rules.
The answer to the question is no. An interline means, and of course the FAQ at the FMCSA is quite clear about this, that if it's an interline, in other words, one motor carrier takes possession of cargo, they must transport in their own equipment a certain number of miles before they turn it into the possession of another motor carrier to actually meet interlining rules. But casual interlining, the practice that was very prevalent up until October, or before October 1st, is now outlawed.
Okay. All right, next question is, for brokers/carriers that use the same MC number, what kind of changes will be necessary to show separation? Would that be a new broker MC number?
When I started out, my MC was 1166998, and I had a brokerage of the same name. I soon came to learn from operating a trucking company and a brokerage very quickly to separate the two, get a separate MC number, separate everything, including FEIN numbers, names, that make it a completely separate and distinct entity. And the law is quite clear on this. In 32915, it specifies that they have to be separate. Now, subject to whatever the government says, and the recent FAQ they published, that these two companies cannot even share the same payroll. I don't think they've gone as far as saying share the same premises. But it has to be distinct, both the shipper and the carrier involved in a brokered transaction.
Okay. The next question, I think it's kind of along the same lines. It says, we are a trucking carrier with broker authority. After October 1st, I cannot broker my freight?
Oh, this is this cloud of MAP 21. The trucking company cannot broker freight, period. Now, the brokerage of that trucking company and the same ownership can broker legally. It's just that the first trucking companies, the ownership who owns the brokerage, cannot be physically involved in the actual motor carrier's revenue. It's quite clear and quite succinct that that's double brokering. So the answer to the question is trucking companies cannot broker. But a brokerage owned by a trucking company has to be a separate and distinct entity and has to deal with the shipper direct and has to pay the trucking company direct.
Okay. Another question that's come in, it says, so as a licensed broker, I cannot have rates of my own, and I cannot charge an FSC. I think that's fuel service charge.
Yes, the government wrestled with this issue. The Surface Transportation issued an ex parte 666. You can look it up. It basically says that fuel surcharges can be charged by only modes of transportation and assessed and collected, and they have to be fair. So in other words, if a motor carrier or if a railroad company charges $128 fuel surcharge to a shipper and then brag on the television that they can move that same trailer 1,000 miles for $68 in diesel, that practice in 666 was ruled unfair. And generally when things are unfair in the right of private action, the carrier who's collecting the surcharge is going to be found wanting. Brokers are not modes of transportation, never have been. Now, if they talk to a motor carrier Smith says, I want $100 for fuel surcharge, they can only assess the shipper $100. They cannot profit in that. They cannot charge a fuel surcharge and collect the fuel surcharge because it's not fair. So here we are with MAP 21. Essentially, the government's going along, and they've been very, very steady in their distinctions and differentiations to separate brokering from trucking.
Okay. Thanks, David. I'm going to answer this next question. There's a couple of them that have popped in. People want to know when they'll be able to receive a copy of this webinar. Obviously, there's a need to share this with other people in the company. There'll be an email that'll go out, and it may not come out today, but certainly first thing in the morning, you'll receive a follow-up email that will have a link that will allow you to sign in and view this webinar recording. So you should have this available to anybody that wants to share it with others. I'm going to say it'll be first thing in the morning. It may not be today, but probably first thing in the morning. Okay, the next question here, gentlemen, is there any grandfather clauses? And follow-up question to that is, how can the carrier set the rates when the broker negotiates with the shipper?
Shall I handle that one, Temple? I guess the first part of the question should be Temple.
It's about grandfather clauses.
No grandfathered clauses. This is all new.
So everybody's got to abide. Nobody gets to play by the old rules.
That's right.
That's right.
Okay.
Now, the second part of the question I'll answer. Brokers negotiate with trucking companies, but brokers who make up their own rates and then tender it to a motor carrier, and the motor carrier says no, the broker's going to have to find another carrier who work for it at less. We, in our school, for the last 26 years of teaching this class, have always taught that brokers ask motor carriers for their rates, add their commission, and quote the shipper. Because if the broker acts like a motor carrier, quotes a shipper, assesses a fuel surcharge to the shipper, and turns around and brokers it to another motor carrier, if that motor carrier has an accident or there's a wrongful death, that broker is going to be held liable because he's acting like a motor carrier. And I can cite in my textbook, for example, Coletta's opinion of 1992 at the FMCSA legal branch. And there are several other things in my textbook that will answer those questions concisely.
Okay. Next question is, what is the ruling on allowing group surety bonds or trust funds?
I think, Temple, that one's for you. Well, at this time, it's in the state of flux. The group bonds are, some are being disallowed with certain entities. The FMCSA is getting involved and disallowing group bonds. And trust funds are coming under fire for not being adequately funded. And so in my opinion, the best bet is to get a true bond. And while this has been fought out in the marketplace.
Can I throw in something, Temple?
Sure, go right ahead.
Well, essentially you're saying that if you're going to get a broker's license or you need to change your existing broker's license, you should opt for a BMC 84, which is issued by insurance companies and people who are already registered with the Department of Treasury. I would not opt for a trust fund until these legal cases. We have one right here in Arizona, Maricopa County, where a trust fund company is being sued. So, so the outcome is like you suggested, Temple, bleary at best. And in my opinion, they're basically postponing the decision. But they'll make it probably within a year, wouldn't you think, Temple?
Yes, and just to add on to that, I would look at new information, new guidance forthcoming. That's why I mentioned in my statement that I think that everyone needs someone that they trust as a consultant on these matters, because as with CSA and hours of service, you can go back on the calendar. You can see almost weekly changes in guidance that has been issued coming forth from FMCSA. So we need a good consultant that you can call and that keeps up with all these things for you.
Okay, thanks, guys. The next question is, my company is an OSB manufacturer with a central dispatch in our corporate office. We currently use 300 plus carriers and brokers to pick up our freight at our mills and deliver to customer locations. Of those, probably only 30 are brokers. Will we need to have the brokers provide us a copy of the new $75,000 bond and sign a new property broker agreement? Please advise.
I'll handle that one, I think. As best advice, and I have a number of large shippers as clients in my forensics practice, I would recommend that if you're working with a broker, make sure that the way that broker is engaging trucking services is in such a manner as to prevent the broker from acting like a trucking company. You may be dispatching brokers and telling brokers to go pick up a load, and let's say trucker Smith drives in to pick up the load. And as a shipper, I would immediately take steps on October 1st to make sure that the truck that shows up for the load, that the bill of lading is made out to that trucking company and MC number. I would also recommend that as a shipper, a large shipper with lots of points of sale, or points of dispatch, as you've mentioned, take steps to verify the carrier that actually shows up for the load has insurance on fmcsa.dot.gov. In other words, there's a minimum duty owed to the public safety of vetting the trucking company that actually shows up. Do not rely on a broker to do this. Although brokers do it as a matter of practice because they're designed to protect you, but as a shipper, you don't want to assign your responsibilities to the public safety to a third party.
Okay, David, thank you. This is a follow-up from the same person that asked the previous question, David. It says, also we have an internal trucking company that leases with 100 plus owner-operators running under our DOT number that picks up freight from our mills and delivers to our customers. Does that then make our internal trucking company dispatchers brokers?
You've got an internal trucking company, and as a private carrier, I think you might even be registered as a private carrier, you have the ability to put freight on any trucking company you'd like, and that trucking company becomes your agent. If you're conducting your business this way, you may be found to be a principal in the event of a wrongful death or a car truck accident or a car loss or cargo loss. So you may want to make sure that your people that are, running your trucking division, that if they have a trucking company, let's say it's the Smith Trucking Company that's owned as a private carrier, and they book a load on Jones Trucking Company, they better open a brokerage, separate that, and they have to issue bills of lading in that other trucking company's name. Their own trucking company that's providing them with probably another profit center is going to have to be careful to comply with the law. If they don't have a brokerage, they better get one.
Okay, thank you, David. The next question is, this has to do with carrier of record versus carrier of execution. The question is, you mentioned the carrier on the BOL must match the name on the side of the vehicle. If BOL is pre-printed as carrier of record, can the carrier of execution cross out and write in their name?
Yes, the bill of lading is the property of the actual hauling motor carrier. One motor carrier with his name pre-printed on a bill of lading is hiring another motor carrier is in fact outlawed by MAP 21. No trucking company under any circumstances can hire another trucking company. Only their licensed brokerage can arrange transportation. So in other words, the trucking company, first trucking company, is taking possession of the cargo, turning around and hiring another trucking company as a principal-agent relationship. It's now outlawed.
Okay. Another question. This is a follow-up to the earlier question we were discussing, interlining. It says, please elaborate on LTL interlining or pool distribution.
Well, it's a gray area. Pool distribution and interlining, the practice of a carrier, for example, taking a pallet, okay, into his possession. Now, under the MAP 21, only his broker can arrange transportation on the other carrier. That trucking company, under his tariff or even under his name, can't be listed on the bill of lading, can't be part of the actual transaction, and cannot participate in the actual trucking company's, the actual hauling carrier's revenue. So that's double brokering.
Okay.
In other words, one motor carrier takes a commission or marks down their freight rate that they actually charge the shipper, and they turn it over to another trucking company, or even if they turn it over to a broker. Both are barred by MAP 21. Only their brokerage can bill and invoice the shipper for that pallet, and then arrange transportation on an authorized and insured motor carrier.
All right. Thanks, David. The next question.
Let me just expand that.
Sure.
You're talking about interlining. I thought I was quite clear. Interlining, if the trucking company A picks up the load at shipper, takes it to his dock, it went from A to B. Those are some of the miles that make interlining legal. The question comes in is that the recent FAQ by the FMCSA means that they have interpreted this number of miles to be a significant number of miles traveled in their own equipment. If this trucking company tells the other trucking company, the actual hauling carrier, to go to the shipper and pick that up, that in fact is illegal. That's double brokering. Only a broker can arrange transportation on an authorized mode of transportation. Thank you.
Okay, thanks. The next question is brokers will not be allowed to quote rates. They must get rates from carriers, add their margin and fuel, and then give the shipper a rate. What impact will this have on the RFP process?
RSD.
RF, like Frank, P as in Paul. RFP.
Oh, request for proposal?
Yeah.
Yeah, that means that shippers send out lists of lanes to brokers. Brokers quote on them, and of course the broker should keep his ducks in a row with the shipper, saying, you know, if I quote this and there's no trucks in the market, I won't be able to find you a truck. But if any broker signs an agreement with a shipper saying, I guarantee to cover this load at this rate, that broker is acting as a motor carrier, and in the event of a loss or a public liability or a wrongful death, that broker is usually going to be found to be liable as a motor carrier. There's a concept called strict liability that has been conferred upon all transportation. In the last 400 years, there are literally millions of cases of where one motor carrier hires another motor carrier. The other motor carrier kills 3 people. The original motor carrier, the first motor carrier, is going to be held strictly liable for the actions of others. And if a broker acts like a motor carrier, he is, in fact, going to be found strictly liable in the event of a loss.
Okay. Thank you, David. Next question is when is the deadline to separate authority?
Temple, that sounds like your bailiwick.
Oh, well, the FMCSA has issued commentary on that, and they have established October 1st is still the date that they have set to have all this accomplished. However, they've also come back and said they were going to do a sweep of their entire database on November 1st, and all who have not complied, they are going to send out letters giving them 30 days to comply. So that is the net effect of 60 days to comply. If you need to keep working, obviously that's would be the case, then get your bond under the 1MC number, and I can say in particular one bonding entity will they will go ahead and remake that filing under the new broker MC number for you at no additional charge for 60 days from October 1st.
Great. Thank you, Temple.
Just to add, while you are separating the two entities.
Okay, good. All right, we got time here for one more question, and it's a little bit lengthy, so bear with me here. We realize that we assume more liability and general financial exposure by operating with our motor carrier and brokerage operations operating closely together, but we have found it to be best for us. Example, our customer will call our trucking division with 20 loads and tender them to us, knowing that we will distribute it between our trucking and brokerage divisions. Trucking will contact brokerage with the load information. Thus, brokerage, has no direct contact with the shipper. Is this outlawed?
Yes, I think it comes down and falls into the bailiwick of multiple commissions. If the shipper gives the trucking company 20 loads, do they mark the load down and then give it to their brokerage? That's quite clearly outlawed. In response to the other half of the question, or the back side of the question, there seems to be no impediment, no reason why the broker can't bill the shipper for the trucker's rate.
Okay. Good. Gentlemen, I think we've pretty much wrapped up our hour. I thank everybody for all your great questions out there, and David, Temple, thank you very much for filling us in on some really important information here today. And as I said earlier, if you've got other questions, you see David and Temple both have their contact information here on the screen. I'm sure they would be happy to hear from anybody that's got questions or is looking for somebody to give them some assistance in this process. But by all means, feel free to contact them. If you would want to contact me, you've got my contact information down there, and I'll make sure that David and Temple get the information. But having said that, gentlemen, thank you very much. It was very important information, and I thank you both for taking time out today to join us on this webinar. So thank you, David. Thank you, Temple. And with that, we'll adjourn. And we hope all of you that are attending today will join us next month on our next best practice webinar. So thank you all very much.